A federal case falls apart. Not because the evidence was weak, not because the investigation was flawed, because a transcription error misrepresented a key phrase from a wiretap recording, and defense counsel caught it. That scenario is not hypothetical. It plays out in federal proceedings more often than law enforcement agencies want to admit. And in most cases, the root cause is the same. The transcription workflow was never built to meet federal standards in the first place. Law enforcement transcription is not a general transcription job with a badge sticker on it. It carries specific chain of custody obligations, security requirements, formatting standards, and vetting protocols that most transcription providers have never even heard of. When those requirements are skipped, the consequences are not just administrative, they are evidentiary. Ditto Transcripts was built with this reality in mind. As a full-service transcription company serving legal, law enforcement, medical, academic, and general business clients, Ditto Transcripts has developed workflows that are specifically aligned with the compliance and security demands of federal law enforcement. That alignment is not an accident, it is the entire design. So who actually needs this level of rigor? Think about an FBI records officer who receives hundreds of hours of surveillance audio each quarter and needs verbatim transcripts formatted for case file submission. Think about a DEA special agent preparing affidavits that reference intercepted calls, where every word attributed to a target must be defensible under cross-examination. Think about a federal procurement team evaluating transcription vendors and trying to determine which ones can actually clear the compliance bar, not just claim to. These are professionals operating in environments where a vendor's mistake becomes their agency's liability. They are not looking for a general transcription service that will try to figure out law enforcement requirements on the fly. They need a provider that already has the infrastructure in place. What kinds of work actually trigger this need? Consider 4 common scenarios. First, Title III wiretap transcriptions. These are federally authorized intercepts, and the transcripts produced from them are submitted directly into federal court proceedings. The formatting, the verbatim accuracy, and the handling of unintelligible passages all follow strict conventions. Second, controlled by recordings. In DEA operations, audio captured during undercover drug purchases must be transcribed with precision. Speaker identification, timestamps, and notations for background noise are all part of a defensible record. Third, custodial interview recordings. When federal agents conduct recorded interviews, those recordings often become key exhibits. A transcript that misattributes a statement or drops a denial can change the meaning of an entire interrogation. Fourth, grand jury and task force recordings. Multi-agency investigations generate large volumes of recorded material that must be processed securely and consistently, often under tight deadlines tied to indictment timelines. Each of these scenarios shares a common thread. The transcript is not a summary. It is evidence. And the workflow that produces it must be treated accordingly. Here is what Ditto Transcripts actually does differently. Every transcriptionist at Ditto Transcripts undergoes fingerprint-based criminal background checks. Not a name search, not a database query. Fingerprint vetting. This is the same standard used for CJIS-compliance, the Criminal Justice Information Services security policy maintained by the FBI that governs who can access sensitive law enforcement data. Ditto Transcripts has built its staffing and credentialing process around that standard, which means agencies submitting classified or sensitive audio are not handing that material to an unknown contractor. On the security side, Ditto Transcripts operates with CJIS-compliant data handling protocols. File transfer, storage, and access controls are structured to meet federal requirements, not adapted from a commercial template. This matters because CJIS compliance is not optional for agencies working within the federal criminal justice system. It is a condition of doing business. Ditto Transcripts meets that condition before the first file is ever uploaded. The transcripts themselves are formatted to federal court standards. That means verbatim accuracy, proper notation for crosstalk and inaudible passages, consistent speaker labeling, and timestamp integration where required. Ditto Transcripts delivers work that enters the federal record without requiring the agency to reformat or edit the output. And because Ditto Transcripts is a US-based operation, there is no offshore exposure. Every person handling your audio is domestic, vetted, and accountable within a jurisdiction that federal agencies can actually enforce. What does all of this mean in practice? It means an FBI records officer can submit a transcript for case file inclusion without running a secondary quality check. It means a DEA agent can cite a wiretap transcript in a federal affidavit with confidence that the document will hold up to scrutiny. It means a procurement team can approve Ditto Transcripts as a vendor, knowing the compliance documentation is real and verifiable. Federal law enforcement agencies choose Ditto Transcripts because the workflow was designed for their requirements from the start, not retrofitted after the fact. If your agency handles sensitive audio that ends up in federal court, the workflow that produced the transcript matters as much as the transcript itself. Ditto Transcripts handles both. Learn more at www.dittotranscripts.com.